Dealing with a separation already in the middle of family law proceedings? Well, there are critical things about how Australian courts handle parenting, property, and safety that most people still get wrong. And those mistakes can cost you time with your children or tens of thousands of dollars in property settlement. In reviewing family law cases over the past year, one pattern keeps appearing. Separating parents and couples are making decisions based on myths that no longer apply, like believing they are automatically entitled to 50-50 time with their kids, or thinking that calling the police during a dispute protects their position when it actually damages their case. So today, you're going to see exactly what matters in Australia's current family law framework in 2026, the 3 biggest myths that put your outcome at risk, and the specific red flags that make the court question your credibility. If you miss out on what I'm about to show you, you risk walking into court with assumptions that could cost you nights without your kids, destroy your credibility with the judge, or leave 6 figures on the table in your property settlement, all because you acted on information that's either outdated or just flat out wrong. Let's get into it. First off, let's get realistic about the situation. Believing outdated information can cost you massively. Let's say you assume you automatically get equal time because that's how it works. You stop facilitating communication with the other parent, or you make major decisions without consulting them, thinking the law protects your right to do so. The court now views that behavior as failing to prioritize your child's best interests, and it can shift parenting time arrangements against you by 30, 40%, sometimes even more. That's not abstract legal theory. That's nights per fortnight without the kids. On the property side, if you don't understand how financial control is now being treated, you could be leaving 6 figures on the table. Courts explicitly consider how family violence, including financial abuse, like controlling bank access or monitoring your partner's spending, impacts someone's ability to earn. That adjustment can mean the difference between a 55-45 split and a 65-35 split on a $1.2 million asset pool. We're talking about $120,000. So that leads me to this. The biggest thing people get wrong about parenting matters is that there is no presumption of equal shared parental responsibility anymore. There's no automatic starting point. Courts begin from a blank canvas and focus on what's actually in the child's best interest, not what parents assume they are entitled to. However, when evaluating best interests, courts place safety at the center, including the caregiver's safety, not just the child's. So if one parent has been subjected to physical or emotional abuse, that affects parenting arrangements, even if the child wasn't directly harmed. Here's what that looks like in practice. If there's been family violence or coercive control, changeovers might happen in public places, through third parties, or using supervised handover services. Courts can also require parents to use communication apps like Family Wizard, which monitors messages. The key point you need to understand here is that you need to put yourself in your child's shoes. Most parents default to thinking about how they feel in the moment or how angry they are at their ex. But the court asks, what's in the child's best interest? Do they love and care for the child, and do they parent in a safe manner? If the answer is yes, then what's best for your child is maintaining that relationship, even if the relationship between you two is broken. On the property side, I see time and time again 3 major factors that matter even more in 2026 that most people just don't realize. First, financial control and abuse. Courts recognize that family violence isn't just physical. If one partner controlled access to bank accounts, monitored transactions, used money as blackmail, like unless you come home for dinner, I won't transfer you the grocery money, this is financial abuse, and it impacts property division. Evidence for this includes text messages, WhatsApp exchanges, transaction records. Even opening your partner's bank mail without permission can demonstrate a pattern of control. Second, financial disclosure is a formal legal requirement. You must provide bank statements, credit cards, superannuation statements, valuations and tax returns for at least the past 12 months before signing any agreement or consent orders. If you hide assets or fail to disclose, courts can overturn your entire settlement, make cost orders against you, and damage your credibility permanently. And here's one that might surprise you. Pets are now being valued and negotiated as assets in property settlement. While they're not treated like children, courts recognize pets have emotional value, so you may need to negotiate who keeps the family dog as part of the overall property split, similar to how you divide furniture or a car. If the pet has significant monetary value, get a valuation. Now, there are ways you can strengthen your family law court case. So here are 3 powerful things most people don't know that can double your strategic advantage. 1. Prioritize communication first. First, before you take any legal action, prioritize communication. Pick up the phone and really try to reduce conflict. The courts reward parents who demonstrate genuine efforts to co-parent and resolve issues collaboratively. If you can show a pattern of reasonable, factual, non-emotive communication, you build massive credibility. 2. The positive action test. Second, if your child refuses to go to the other parent's house, your response determines everything. It's not enough to say they didn't want to go. You must take positive action, talk about the visit in an encouraging way, frame it positively, attend every single handover even if they refused last time, and actively support the child's relationship with the other parent. Courts reject the defense of, "I tried, but they didn't want to go," if you didn't genuinely facilitate it. Third, the first 7 days matter. Third, the initial days after separation set the tone of your entire case. Start documenting everything straight away. That means key dates, communication attempts, financial transactions, and parenting interactions. Open a separate email folder, use a simple breach log, and keep records factual and non-emotional. This evidence becomes critical months later. Now, let's talk about what not to do when you're dealing with your own family law case, because these mistakes cost people time with their child and money every single week. Mistake 1, calling the police. A lot of people think that if a dispute happens, calling the police strengthens their position. But when police attend a parenting dispute where children are present and there's no actual danger, it's called systems abuse. You're exposing your child to unnecessary conflict and stress, and that works against you in court. Plus, once you call the police, they have a duty to notify Child Protection Services, which brings a whole new layer into your case. Only call if there's genuine immediate danger. Mistake 2, recording your spouse or sending inflammatory messages. Recording your spouse without their knowledge can backfire badly. It can be a criminal offense under surveillance laws, and it damages co-parenting trust. So are inflammatory or threatening messages, refusal at changeovers, or withholding the children in retaliation. Destroy your credibility. Courts see straight through reactive behavior. To get around this, keep communication factual, non-emotive, and documented. Mistake 3, assuming a 50-50 split. The third trap is walking into negotiations, assuming the property split works like a math equation. It doesn't, and very rarely are things split 50-50. The court doesn't start at equal and work backwards. They look at financial and non-financial contributions from both parties, future needs like earning capacity and caring responsibilities, and then make adjustments. Fairness doesn't mean equal. It means just and equitable based on your specific circumstances. If you walk into the mediation demanding 50-50 because it's fair, or refusing to disclose premarital assets because they shouldn't count, you are negotiating from a position that doesn't exist, and that costs you time, money, and credibility. Mistake 4, poor disclosure or dissipating assets. Finally, do not make large withdrawals, transfer money to family members disguised as loans, or hide accounts after separation. Courts can restore dissipated assets as notional property, meaning you are credited with still having money even though it's gone. With stronger disclosure requirements being enforced, forensic accountants will find it. The penalties include cost orders, overturned settlements, and destroyed credibility. Now that you understand what matters in 2026, what mistakes to avoid, and how courts actually evaluate parenting and property, the next question most people ask is, how do I lock in an agreement without spending $50,000 in legal fees? That's where binding financial agreements come in. If you structure them correctly, they can save you $20,000 or more in legal costs and months of court time. Watch this video next, where I break down exactly when BFAs work and when they don't, and the 3 mistakes that make them unenforceable. And if you need tailored advice for your specific situation, we've left a link in the description to book a strategy call with our family law team. We'll walk through your circumstances, map out your options, and show you how to protect your position from day one.